All right, good afternoon, everybody. Today we're going to hear about the career as a criminal defense attorney with Attorney Rosetto. But before that, let's do a check-in. And as you know, you need to check in so that your teacher knows that you're here in this event and not anywhere else where you're not supposed to be. And if you have questions, you can refer to this great questions documents and then put your questions in the chat or raise your hand. And you can also turn on your camera because it's not going to show up on the recording. And the evaluation form is very important. As you know, you need to submit the evaluation form so that you will get a credit, and that is required for you to graduate. And be fully present. This is a good time to ask questions. And again, submit your evaluation. Again, this is really, really important. That is it for me. Let's have Attorney Rosetto.
All right, how do I get my PowerPoint up? Share screen?
Yeah, so there's a green share screen and then you get to pick which one.
I think I've got it. Can you guys see that PowerPoint?
Yes.
Does that look good? All right,
Yep,
thank you. Sorry.
good.
So I've been using Zoom for the last almost 2 years now during the pandemic to do all sorts of meetings, but I haven't done a PowerPoint yet. So anyways, now that it's good, I'll get started. As she said, I'm here to talk about criminal defense. I wanted to start actually with this slide. I have a feeling that some of it's maybe cut off from the Zoom display, but I thought that this little slide was a pretty good representation of my job. It was actually just a theme in PowerPoint, but the first and most important thing on here is the mug of coffee. If you don't drink coffee, you probably won't be a very good attorney. It's a staple, it's required. I drink it all day long. And then the keyboard, my job requires so much typing between emails, document drafting, reviewing evidence, all sorts of things. A lot of my job is on the computer, lots of writing, lots of Post-it notes. So I thought that was a pretty good representation, but it was missing a couple things. You need a cell phone, and then in order to work safely while on the road, AirPods. So now we have a perfect representation of what my job actually looks like. As you can see, I have a PowerPoint presentation prepared, but by virtue of my job, I'm pretty good at thinking and talking on my feet. I kind of have to. I'm used to being interrupted and peppered with questions. So I don't know if there's a prescribed way for us to do this. I don't know if you're supposed to save your questions till the end, but I don't care if you ask questions while we're going. I would actually prefer it. While something's top of mind, please just ask. Am I supposed to be monitoring the chat window or anything to do that?
We can ask the questions, or you can also you can choose whatever. But if you want, we can ask the questions on the chat.
I actually, when I have the slideshow full screen, I don't necessarily see the chat. So if you just want to let me know when there's a question, I'd be happy to take it.
All right.
Okay. All right. And then with that, I'll get started. So first, who the heck am I? My name is Tucker Rosetto. I am an attorney, as was said. I work for that law firm there at the bottom, Gilroy Napoli Short Law Group. I'm 34. I'm married. I have 2 kids, a kitten and a dog, and that's why I have these bags under my eyes that don't look very good on this camera. And I am a criminal defense attorney, most importantly, right? Because that's why I'm here talking to y'all. In a nutshell, that means I represent folks who are under investigation for committing crimes or who have been formally accused of and charged with committing crimes. The majority of the time it's the latter, right? Somebody's been charged with a crime, and so then they need to hire an attorney, and I'm who they've chosen to represent them. But sometimes folks know early on that they're under investigation. A cop comes to their house or a detective. They realize, oh, I should probably get a lawyer now. And so sometimes I'm brought in ahead of time, really early on. But most of the time it's after a person's already been arrested and charged that I represent them. And I'm going to talk more about what that means and how I got here, but that's it in a nutshell. So, I was formerly a prosecutor, and I'm going to talk more about that too, just a little bit, since that's not really the focus of my presentation, but it's important for you to know that because that's the other side of what I do. Our whole legal system, but in particular, the criminal justice legal system, is what we call an adversarial system. So it's one party versus another. In a criminal case, that's the state of Oregon, a prosecutor versus my client and me on their behalf. So I used to be representing the state and prosecuting folks, and now I defend folks. And I'll explain more about what that means. So what does that mean? Some folks think that means that my job is just trying to get bad guys off the hook, right? Trying to let bad folks get away with things. And I can say that is not farther from the truth, at least in my experience, in multiple ways. The vast majority of my clients are good people who did do a bad thing, but they are at heart good people, and they made a mistake. I truly like the vast majority of my clients, and they are, remorseful for what they did, have sincere regrets about it. Yeah, but some are bad. Yeah. And certainly I'm not going to say that every single person who's committed a crime is a good person. So some are bad, but whether they're good or bad, I'm not trying to get them off the hook necessarily. I am trying to make sure that they are treated fairly, respectfully, and equitably. Because at the end of the day, people who commit crimes, people who are charged with crimes, they are still people, right? With feelings, emotions, lives, families, kids, jobs, and they all need help. They all need to be treated fairly. And that is a big part of my job. And to break it down, I would say to start with, I'm both counselor and counsel. Counsel is just another word for lawyer. But counselor, I think we all know what that is, right? That's somebody who you talk to about your problems. They walk you through that. They help you with that. They counsel you and advise you through it. And most of my clients, if they're reaching out to me, they are going through the worst moment of their lives, right? Again, most of these people are good people and have never been involved in the criminal justice system before. They've never talked to a cop before. They've never been accused of a crime before. And now here they are, worried about the impact a conviction might have on their future employment, going to school, getting into schools, whether they're going to go to jail and for how long. They're worried about being able to keep their job and their house. They're worried about their family. Sometimes folks are, sorry. No, there's not. They're really different terms for the same thing. Sorry. So in regards to the question, is there a difference between a lawyer and an attorney? Not really. I think that for the most part, they're used interchangeably. I think that there is a difference in some contexts where like a lawyer is a person who has gone to law school and has a law degree, but an attorney is a person who actually practices law. But for the most part, they're interchangeable terms. But regardless, to go back to what I was saying, my clients are going through the worst moments of their lives. They are super stressed. They're often very scared and have no idea what is happening, what is going to happen, what to do. And a big part of my job is just listening to them, just hearing them out, hearing their concerns, hearing their grievances, and walking them through it and giving them, well, I'll get to that part next, but it's actually a lot of counseling, which surprised me when I started this job. It was a big adjustment from being a prosecutor where you don't have clients, you're just representing the state, right? There was no one-on-one personal relationship with somebody on the other side. Whereas now it's very personal. I am that person's attorney and I have to learn everything about them, good and bad. But beyond that, sorry, I'm trying to go to the next slide. I am an advisor. So not only do I hear out my clients, their lives, their circumstances, their situation, their concerns. But then I get the evidence that the state has against them. Usually that's police reports. Sometimes there's camera footage. Sometimes there's pictures. There's other things. I look at all that to assess the strength of the state's case against my client, determine what it is I think that they did, what I think they didn't do, what I think that they could be convicted of. I look at, then from there, what are the possible consequences my client's looking at? What's best case situation, worst case scenario? I look to see if there are any issues or deficiencies or shortcomings in the state's case. Make sure that my client's rights were respected. If it wasn't, is there something there I can fight on their behalf? And then at the end of the day, after all of that, when and negotiating with the prosecutor, I have to advise my client on what to do. I can't tell them what to do. It's their life, it's their call. But a big part of why they hire me is just for my professional opinion, because they haven't been through this. They don't know what options they have. They don't know what the consequences may be. And so they want to know from me, what should I do? And that's a big part of my job, is just advising them on their options and what I think they should do, what I think they shouldn't do, and what could happen with either course of action. And to be clear, so folks know often what we're talking about in the context of a criminal case, where a person's been charged with a crime or several crimes, your options are: best case, you try to get the prosecutor to dismiss it. Maybe you're trying to get evidence or information that the state doesn't have that changes their thoughts on the case, and maybe you get it dismissed, and that's best case for your client. Maybe you're talking about taking a plea deal, meaning you've reached some sort of agreement with the state where my client will plead guilty in exchange for an agreed upon sentence. Or maybe I tell them to enter a guilty plea, meaning take responsibility, admit to what they did, but without a plea deal. So we don't know what the sentence is going to be. And then that's up to the judge, or go to trial. And I'll talk more about trial later and what that means. But that's the case where you haven't reached a plea deal for various reasons, or you're not going to enter a plea in front of a judge for various reasons. Maybe it's because my client's innocent, which does happen. And so we want to go to trial and have them found innocent so that there aren't any consequences for them. I'm going to look at this chat. Why? So the question is, why did I switch to a defense attorney from a prosecutor? And I'm going to cover that later. So I promise I'll come back to that. Oops, I accidentally clicked two ahead. I am also my client's advocate. When a person is charged with a crime, I know as a former prosecutor what that looks like on their side, right? A prosecutor gets involved after a crime has been committed. Police have conducted their investigation, and then the police have sent off their materials to the prosecutor for their review. So prosecutors, usually the majority of the time, they're just getting police reports about this one distinct incident, the crime. And then the prosecutor is making a charging decision based on that. And then they're also making their decisions regarding what they think is an appropriate outcome to the case when we're doing plea negotiations based on that. And that means all they have are police reports talking about the bad thing that my client did. And then if they have any prior experience with the criminal justice system, they're also looking at their background. It's all bad stuff, right? They're only seeing the bad things about my client. They don't know the good things that they've done. They don't know the good things they have going on in their life. They don't know about their family situation, their job situation, schooling, medical stuff, whatever. I do though, right? That's why I talk to my client. I learn all of those things. And then it's my job to paint a more complete picture of my client to the prosecutor so they know who it is that they're dealing with, but also to the judge. You know, I want the court to know who my client is and the good things about them. And then I fight for them, right? To make sure, again, to go back to what I said earlier, that they're treated fairly and respectfully. most folks, again, they've never been in the system before, or even if they have, they don't really know how it works or what to do or what to say. So it's my job as their representative to be their spokesperson. And I'm the one there in court, in negotiations, fighting for them, advocating for them. And then kind of tying all that up together, I also look at my job as being a check on the system. Just because somebody is accused of a crime or crimes doesn't mean they committed them. Or even if they did committed a crime or some of the crimes they're accused of, it also doesn't mean that the process that the police went through or the prosecutor went through was lawful and appropriate. Cops have a very difficult job. I respect the heck out of them. They often do a great job, but sometimes they do things wrong too. And sometimes the things that they do are wrong or significant, right? We all, as citizens and even non-citizens, have legal rights in our Constitution and in our state statutes. And sometimes when police are performing investigations, they violate those rights. And it's my job to make sure when I'm talking about treating my clients fairly and respectfully, that I'm also making sure their rights were respected and followed. Both in the past when they were investigated, because there can be consequences to the state for that, but also going forward, right? While their case is pending, make sure that the prosecutor is doing everything appropriately. Make sure the court is doing everything appropriately. When I say the court, I mean the judge. Judges are just attorneys, usually, who have been doing it for a long time, and then they get appointed or elected. They can make mistakes too. And so it's my job to make sure that every other player in the system, the police, the prosecutor, the judge, they're all doing things right. And I'm looking at that from my client's perspective and making sure that they're treated fairly. Okay, so this question is, do I know beforehand if my client really did it or not? It's a good question. It's a conflict, and it has a complicated answer. So often, the majority of my clients, they come to me after they've been arrested and they have a future court date. And so their case is already kind of starting. And so my first exposure to their case, the first time I learn anything about their case, is just from my conversations with them. So first, I'm just going off of what my client can tell me about what they know, what they remember. Then as the process unfolds, I start to get materials from the state, police reports, well, always police reports. Nowadays, more often, we're getting video footage because most cops are wearing body cams. So all their interactions with folks like my clients are recorded. So I get that. If there's pictures, medical records, other things, I get those too. And to go back to the question, I would say that most of the time, I know what my client did, if they did or didn't do it, because they tell me. Most of my clients, maybe I'm naive, maybe I'm gullible, but I believe the majority of my clients, and most of my clients, admit to doing what they did, or at least to, they would say that I did a lot of what I'm being accused of, or part of what I'm being accused of, but maybe this part's not true. And so sometimes it's my job to demonstrate and display the whole truth that my client is giving me. Sometimes I think that my clients are actually innocent and didn't do what they were accused of when they're telling me that they didn't. And sometimes my clients are telling me they didn't do it and I believe they did, right? It's the truth of the job is that we do get lied to sometimes for various reasons. And sometimes it may just be that our client doesn't want to admit that they did something bad. And so they'll deny it, even though all the evidence is pretty overwhelming against them. So sometimes I do, sometimes I don't. I think the reality is also that often I will never know the full truth, right? I think in my line of work, you have the state's version of events that comes up through the police investigation. You have my client's version of events, and the truth is somewhere in the middle. And we all do our best to find out what that truth is, but sometimes we will never know the whole truth. Okay, a whole bunch of questions. So I'll go through them in order. What do you do if all evidence points that your client is guilty? How do you defend that client? Most of my clients are guilty. The vast majority of them are. and they would admit that. Most of my clients don't come to me saying, I didn't do this or I'm innocent. It's all about just making sure that in the end, they're treated fairly. The most common case I represent is driving under the influence of intoxicants, DUI, right? Somebody drank too much and then they went out and drove and they got caught. And most of them admit, yeah, it was a stupid mistake. I shouldn't have been driving. I feel terrible about it. When you say, how do you defend that client? Again, most of these people, I'm not trying to prove their innocence. That does happen. There are folks I do that for. But for most folks, I'm just trying to make sure that they get treated fairly. So that client who got busted for DUI and they admit that they got busted for DUI, I just make sure that they have a good outcome to their case. I'm there for them to explain the process to them, to walk them through it, to help them, and then just make sure that they get a fair and reasonable outcome. The question might be geared towards what I said, where my clients say that they're innocent and the evidence points to them being guilty. And that just depends on the case. One comes to mind where she insisted that she didn't do it. I think a big part of why she said that and maintained that was her family. Her family couldn't believe she had done it. And she was very young and she couldn't bring herself to tell her family that, yes, I actually did this. And basically I just had to reason with her and tell her, regardless of whether you did it or not, the evidence is overwhelming that you did. And if we go to trial, I do believe you'll be convicted. And so we worked on getting her a fair and reasonable outcome to her case. Let's say though she wanted to go to trial, then those are the harder cases, right? Where I believe my client's guilty and they want to go to trial. And really, when you're talking about trial at that point, it's you're trying to prevent them from being convicted. But then that's just when I kind of fall back on my role as being a check on the system. And I just make sure that the state proves their case like they're supposed to, and that they do it all appropriately and that there's sufficient evidence. And then if they get convicted, they get convicted. And then we proceed to sentencing. And I try to make sure that at that point, they're treated fairly. Okay, let's see. Do the prosecutors view the evidence as well or no? They do. They're the first ones to do it. So when police conduct their investigation and then either they arrest my client or they just refer the case to the prosecutors for them to decide what to do before arresting my client, the prosecutors always review the evidence up front before they make their charging decision. Now, that being said, they don't necessarily review all of it. So sometimes what happens is, well, at a minimum, they review the police reports. And as a former prosecutor, I know that most of the time, prosecutors make their charging decision just based on the police reports, which are reports written up by the officers involved in the investigation. That's all it is, just written reports by the cops. But then sometimes they'll charge my client. But then we get things like the video evidence or pictures, and maybe it conflicts with the police reports. Well, I know the prosecutor probably hasn't looked at that yet. So then I tell them, hey, you need to watch this. You need to see this. You need to look at this. And then they look at it and maybe reassess. At some point, though, the prosecutor will look at everything. Like if a case is set for trial, both sides are going to be poring over everything. So they make sure they know absolutely everything before it goes to trial. But generally speaking, yes, the prosecutor always views the evidence. Now, the other part of that is sometimes we conduct our own investigations. I'm going to talk about this a little bit later. Sometimes we hire investigators to do our own investigation and get our own evidence. And we provide that to prosecutors, either trying to get them to dismiss a case or negotiate it more favorably for my client. And I hope they review that evidence. I can't make them, but I certainly hope they do. The next question is, have I ever fired a client? Fired once. So one thing I was going to talk about later, I'll talk about now, is I'm a private defense attorney. So folks have to hire me. They realize they need to get an attorney. They search for an attorney. and they find me and they hire me, or they're referred to me and they hire me. A lot of folks, though, who can't afford an attorney, since they have a legal right to an attorney, they get appointed one by the state, and it's a lot cheaper, and that's called public defense work. So I don't do that. I don't do public defense. I do what's called private or retained work. And so there's a business side to what I do as well. And the one client I can think of that I quote unquote fired, we entered into a contract, a payment plan. He was supposed to pay a certain amount at different points, and he wasn't paying. And that happens all the time, where folks get behind, or things come up. I always work with my clients. I don't want to stop representing somebody over money. I'm super flexible with it. That's my least favorite part of the job, is the business side of things. But this particular guy, it was going on and on and on. It was a lot of money, and eventually he started lying to me about it. And he made up this very convoluted story one time about why he couldn't come in to pay. He said the cops were at his house and mentioned all these things. Well, he made a mistake in saying the cops were at his house, because then I got worried, and I'm thinking, well, I'm his defense attorney. I should figure out what's going on. I should get involved. Well, I started calling around and realized it was all a lie. He was just completely making this up. He, in the process, was violating all sorts of conditions of his jail release. It just was not working out. And at that point, I realized I can't represent this guy anymore. And I ended up withdrawing from that case. And then I later found out about a whole bunch of other things he lied to me about too. But that was a very isolated incident. That rarely happens. I've had maybe 2 or 3 other clients where they couldn't afford to continue my representation. Most of our agreements, they just pay up front, and then it covers everything. Sometimes we enter into different types of agreements where maybe they're going to pay as we go, and folks just weren't able to keep paying. And so it was very amicable. It was just an agreement that, hey, you can't pay anymore. I can't keep working for free. And they're like, I understand. And we separated that way. But I've never fired a client over things like disagreements, or because we got into a fight, or we couldn't work through some sort of issue. So I wouldn't say fired. It was more just money reasons. So that actually goes to the next question. Have you ever had a client who did something so awful or undefendable that you had to drop them? No, I haven't. I will say that there are some cases I just won't take, though. There are certain types of cases that I just don't want to get involved in. And so when they come to us as a business lead, they say, hey, I need an attorney for X, Y, and Z. I'm just going to point them elsewhere. But because we kind of go through a process where folks either get referred to us from somebody else, or they find us online, or they find some advertisement, and then they reach out to us, and we talk about their case, their situation, what's going on. And it's kind of a mutual interview, right? They need to decide, do they want to hire me? But I also get to decide, do I want to represent them? And so I've never gotten into a situation where I entered into an attorney-client relationship and then didn't want to. I mean, sometimes I've gotten into relationships where I realized that the client was super disagreeable or not fun to work with, but never so bad that it was awful, or it felt undefendable and I had to withdraw. Have I ever defended a client with mental health problems? Yes. Sadly, the reality is that most criminal defendants with mental health problems are not going to be in a situation to hire an attorney. Most of those folks are going to be getting appointed attorneys from the court because they don't have enough money. But nonetheless, I have represented some. Usually it's because their family is paying for the representation. And it is its own particular kind of challenge doing that. Sometimes it's not really a challenge. Part of my job as a counselor is sometimes talking them into getting help, getting into therapy, getting into treatment, seeing their doctor, getting on medications, and they do, and they're fine and they're easy to work with. Sometimes they're very hard to work with when they don't do those kind of things and they're not taking care of themselves for whatever reason. And then going back to my job as an advocate, it's my job to make sure that everybody else realizes this is a problem too, right? And that often played a big role in their criminal conduct. I would say I've probably only represented folks with mental illness a handful of times. I mean, lots of folks with PTSD, depression, anxiety, ADHD, those are pretty common. But as far as like things like schizophrenia or bipolar disorder, not too often, but I have. I think that covered all the questions for now. Okay. Sorry, bear with me. All right, so to give you an idea of what a day in the life of a criminal defense attorney looks like, I prepared this slide. I will say that it's very busy. Every day is super, super busy, but in a good way. I've had jobs in the past where, I'm constantly looking at the clock, being like, is it 5 o'clock yet? That doesn't happen anymore. Usually more now it's like, oh my God, it's already 5 o'clock and I still have so much to do. So super busy, but I think it's good. Keeps me busy, keeps me engaged, helps the day fly by, and it's all important. That being said, while it's busy, it probably isn't going to sound super exciting to you. And let me see what that says. The question is, what type of education do you need to do this? Do you have to go to law school? Yes, absolutely. And I'm going to cover that later. All right, so first, I may have court in the morning. Going to court is a very frequent and regular part of my job. On average, I go to court 3 times a week. I looked at my schedule this week just to see if that was true, and it is. I had court Monday, I had court this morning, and I'll have court again Friday. And that can be all sorts of different types of appearances, but just know that I am actually in court with my client, with the judge, with the prosecutor several times a week, sometimes several times a day. There was a Monday last week where I had 5 court appearances in one day. That was pretty miserable. I try to not do it that way, but sometimes it happens. And like I said earlier, I am always on my phone, usually with clients, but sometimes with coworkers, prosecutors, probation officers. There's all sorts of folks I need to talk to all the time. Then let's say after court, which maybe court only took a few minutes, maybe court took a couple hours, I go back to the office and then I do evidence review. Maybe the state gave me what we call discovery, which is the evidence on a client's case. They just provided that. And now that my client's been charged, and so now I'm reading the police reports, seeing what evidence the state has, and getting a better idea of my client's situation. Usually during that time, I'm getting more phone calls, more text messages, sending emails. I used to give, when I first started this, I gave all of my clients my cell phone number. I quickly came to regret giving it to everybody because I realized I no longer had any barriers whatsoever, and I was getting texts and calls all the time. I still give it to a lot of my clients, but not everybody. And let's see, more questions. Do you only take 1 case at a time? If not, how many on average? It's certainly not just 1 case at a time, because a case on average is going to take probably 30 to 90 days to resolve, and it's not going to need full-time attention all the time. And some cases take years. So right now my caseload is actually really low. I'm not exactly sure why. It just ebbs and flows. I have about 40 active cases right now. The highest I've ever had at one time was about 55, 56. And that's just for me. Different attorneys have different arrangements. They do it differently. I know some attorneys who don't take more than 20, 30 cases at a time. I know some that have 80 at a time, but I'm usually around 40 to 50. Oh, and then that answered the next question too. How long do you typically carry cases for? A month, multiple months, a year? COVID has changed that. Before COVID, cases would be like expected to resolve within 30 to 60 days. If it was going to trial, you would expect to go to trial within 3 to 4 months. But now cases are taking a lot longer. And I have some cases that are years old. It's normal for cases now to take several months. Sometimes though, they still wrap up in as soon as 30, 45 days, but usually months. And the next question is, what is pay like for this job? That varies a lot. One thing I was going to talk about later is public defense versus private. Public defense does not pay very well. It's an issue that is currently kind of a hot topic in the state and at the legislature, because there's been some reports that have come out recently talking about issues with our public defense system. So maybe someday there will be raises in their system, in that system. Like, they don't get paid anywhere near what prosecutors get paid, for example. I think public defenders make around, well, public defender is a broad term. There's some people who are private attorneys who take public cases. There are people who only do public cases. There's people who work at public defenders' offices. Those folks get I think $50,000 a year, and they're not state employees, so they don't get state benefits or anything like that. I make $110,000 a year, which is fairly average for a private defense attorney. I mean, maybe towards the middle. There's certainly folks who make more. There are folks who have been doing this for a really long time and are really well known, really renowned, or specialists who maybe make a fair amount more. But I'm making what I made as a prosecutor. We've basically I've kept my pay kind of on track with what I would have made there. Then after evidence review, then I'll have some sort of client meeting. Maybe it's to go over that evidence with that same client. Maybe it's to meet a brand new one. Maybe we talked on the phone and then they're coming in to finalize things and sign a contract. Maybe it's to go over plea paperwork and talk about entering a guilty plea and being sentenced. Or maybe we're going over trial strategy, right? I meet with my clients all the time. And then maybe I have another court appearance in the afternoon. And thanks to COVID, a lot of our appearances are by phone. Not as many now as we were doing for a while. There was a period of time where almost every court appearance was by phone. Now it's probably about 50-50. So my court appearance this morning was by phone. The court called me and called my client, and we were on a speaker in the courtroom, and we just took care of our court appearance from my office. Then maybe after that, I call up a prosecutor or I email them with a bunch of information on behalf of my client and a plea proposal, or they've already sent me an offer and maybe I'm trying to negotiate something lower or better for my client. Then there's more emails, more phone calls, more text messages. It's a constant theme throughout every day. And then maybe I'm preparing for trial. And this is where I said I was going to talk a bit more about trial. I am what folks would call a trial attorney. There are tons of different types of lawyers and attorneys out there. They're mostly broken down into like two fields, civil and criminal. Criminal just being what I do, folks charged with crime, so either prosecutors or defense attorneys, and then civil is everything else. Most civil attorneys don't go to court. And even those that do, most don't go to trial, or if they do go to trial, it's pretty rarely. Criminal lawyers go to trial all the time. When I was a prosecutor, I went to trial about once a month. I had about 40 trials when I was a prosecutor. As a defense attorney, it's not quite as often, but a big part of that's been because of COVID. I became a defense attorney 2 years ago, right when COVID started, and that really changed things. So I've actually had 4 trials in the last 4 months, but before that, because of the pandemic, I didn't have any as a defense attorney. So I guess now that things are kind of returning to normal, I'm averaging about 1 a month again. Some some trial attorneys love it. It's the highlight of their job. It's why they do it. Some hate it. I'm kind of in the middle. Trial is exciting. It's different. It's the time for you to really like display everything that makes you a good attorney. And it's also like the most important part of your client's case, because it's like at that point, for that one day or 1 week or however long your trial is, all you're doing is focused on that one client and hoping, working, striving towards making sure they're found not guilty, or at least not guilty of the things they're not guilty of. So it's very exciting, but it's also very stressful. And the reason I put trial prep on there last is often I'm preparing for trials when I can in between all my other work, but often I'm doing it at night, because it takes hours and hours reviewing everything, thinking of everything, prepping for everything. And even though I've been doing this for many years now, I often am up till 1 a.m. day of trial going over everything for the 20th time, just to make sure I know everything about the case before trial starts. See, there's more questions. So first question is, are prosecutors hired privately? So prosecutors are state employees. They're county employees. They represent the state of Oregon, but they're county employees. So each county has one elected district attorney. So the head prosecutor for your respective county, Washington, Multnomah, Clackamas counties, they run for election, and then when they're elected, they then become the head prosecutor for that county. Usually they stay the head prosecutor for a long time. Usually they're not challenged. And then they hire their deputy district attorneys, their prosecutors. So they are government employees, but they are hired by that respective office. So I'm not sure what you meant by privately. They're not private employees in the sense that they're government employees, but they are hired by a district attorney, and usually they go through like a committee or a panel of interviews with prosecutors from that office. So like myself, I'll jump ahead a little bit. When I became a prosecutor, I had actually previously worked in the Washington County District Attorney's Office as a law clerk while I was in law school. When I graduated law school, I became an attorney doing something else. I hated it. I wanted to go back to criminal law. And so then when there was an opening in Washington County, I applied. I already knew everybody there, but I still went through the same process as anybody else. And I went through 6 different interviews with prosecutors, then the chief prosecutors, who are like the second and third in command, and then lastly an interview with the elected district attorney, and then he made the decision to hire me. Is it true you aren't supposed to ask questions you don't know the answer to? That's a good question, because that definitely is a saying, something that people say. It depends. It depends on, do you think you know what the answer is going to be? What is the potential harm of a bad answer versus what is the potential benefit of a good answer? I don't think having that as a blanket rule is a good rule. I have gotten out great pieces of testimony from asking questions that we didn't know for sure what the answer was going to be. I've also elicited answers that were really bad for me by asking that question, both as a prosecutor and a defense attorney. Often if you know the answer, that's just because it's in the police report. And police reports are, I don't mean to be like critical or judgmental here, but they're pretty one-sided, right? It's the police officer's report of their investigation trying to prove that their suspect committed a crime. Often there's all sorts of other information out there that maybe they didn't include in their police reports. So you have to ask questions you don't know the answer to, and sometimes you just have to take that risk. And usually it pays off, or it's not really going to impact the case either way. Sometimes it's harmful. Why did I choose to be a defense attorney? I'll get to that in a little bit. And then, do you work overtime? Is there a work-life balance? Yes, I work overtime. I mean, I'm just paid a flat salary. I'm not paid hourly. So it's not like I have 40 hours a week, and then I'm going overtime. But do I work more than 40 hours a week? Absolutely. Often long days at the office. Sometimes I'm working from home at night. I have worked on the weekends, but again, I have 2 kids and a wife who really wants help with those 2 kids. So I do my best to not work on the weekends and not work too late at night. And I don't think I work too much. And I have found a pretty good balance. The other thing that's nice about my job now versus being a prosecutor, when I was a prosecutor, no matter what, I had to be at the office from 8 to 5. Even if I had been there till 10 o'clock the night before prepping for trial, even if I had a terrible week-long trial the week before and was working late every night and came in on the weekend, I still had to be there 8 to 5 every day. Here, my bosses don't care when I'm here. They don't care where I'm working from, just so long as I get my work done. So I get to take my kids to school. I'll come into the office, not at 8, I'll come in after 8, and then I can work a little bit late if I have to, or I can go home, see my kids, and then after they go to bed, I can work from home. So do I work a lot? Yeah, but the work-life balance is pretty good here in that it's pretty flexible. Does your client pay the firm or do they pay you? My clients pay the firm. We have a lot of overhead, right? We have numerous offices, we have advertising, we have a whole staff, right? We have an office manager, receptionists, legal assistants, there's all sorts of folks here. So like my fees, when people are hiring me, they're paying for everything. So they pay the firm and then the firm pays me. Now, some people are different, right? There are attorneys who are what we call solo practitioners. They have their own practice. It's just them. And in that case, it would be different. But here, working for a firm, the payment goes to the firm and then my bosses pay me. What happens if you are sick and you have a trial on that day? Fortunately, I haven't had that happen, but it does happen. It's certainly happened a lot during COVID, where either an attorney is sick or a judge gets sick or a witness or a victim gets sick. It just has to get rescheduled. Pre-COVID, it would depend on the judge and the sickness, and a particularly difficult judge. If it was just a cold, they might tell you too bad, come in anyways. Most of the time though, they would be okay with it rescheduling. But during COVID, everybody's been so cautious. If you were to call and say, I've got a sniffle, they're going to say, okay, we're resetting it. Don't worry about it. I actually did have a trial. It would have been my 5th one back in December. We showed up. We had some pre-trial arguments. We were arguing over the admissibility of evidence. So jury wasn't in there yet. It was just the prosecutor, myself, my client, and the judge. We were about an hour in, and the judge called a break. And then a while later, he told us he was feeling sick. And so even though we were like midway, we just had to stop and pick new dates, and he went home. So it happens. And usually everybody's pretty flexible and accommodating about it. All right. I'm running a little short on time, but I wanted to give you a real life example. I'm going to kind of go quickly through this. So this is a real case. It's one I just dealt with recently. I've just changed my client's name. And again, I'm going to try to go through this pretty quick. So Mr. Jefferson was accused of several serious crimes. He was driving under the influence of alcohol. He was intoxicated. And he crashed. He got into a very serious car accident. He was hurt himself, and he seriously injured the other driver. The state charged him with numerous crimes: assault in the 2nd degree, assault in the 3rd degree, DUI, reckless driving, and criminal mischief. Criminal mischief meaning he damaged property, reckless driving meaning he was driving recklessly, DUI meaning he was driving under the influence, and then 2 different types of assault. In Oregon, we have crimes by degrees and classes. So assault in the 1st degree is the most serious, then assault in the 2nd, assault in the 3rd, assault in the 4th. And they charge him with assault in the 2nd degree and assault in the 3rd degree. My client and I, this is a case where my client admitted he was guilty of DUI, of reckless driving, of criminal mischief, and even of assault in the 3rd degree. But he and I both disagreed that he was guilty of assault in the 2nd degree, the most serious thing he was charged with. The state wanted him to go to prison for 4 years for this. He was 26 years old. He had a good job. He was a college graduate, but he had an alcohol problem. And after this incident, he went through a bunch of treatment. He stayed in treatment for a super long time. He was on 24/7 supervised release from the jail for like 15 months while his case was pending. They had him wearing an alcohol monitor to make sure he didn't have a drop of alcohol. And for 15 months, he didn't. I made a plea offer to the state where my client would plead guilty to those 4 things that we thought he was guilty of, and offered for him to do, in addition to a whole bunch of other things, 4 months in jail. State wanted 4 years. We said, how about 1 year? They said 4 years. How about 2 years? They said 4 years. They weren't coming down from 4 years. And the problem in his case was that assault in the second degree charge, that falls under what we call ballot measure 11 in Oregon, meaning it has a mandatory minimum sentence. If he were convicted of assault in the second degree, he would go to prison for over 6 years. And the state's plea offer of 4 years, he actually would have been eligible to get time off. So in reality, that 4-year sentence probably would have been like 2.5. But if he was convicted of assault in the second degree, it would have been 6 years and a full 6 years. He couldn't have gotten any time taken off. If the state wouldn't agree to something, the judge couldn't do anything else. The judge would have to impose that full 6-year prison sentence. So my client's options at the end were take the state's offer of a 4-year prison sentence that would be more like 2.5, or go to trial. And if he were to win, the judge could impose pretty much anything he wanted. Theoretically, no jail. That was unlikely, but it was a possibility legally. But if he was convicted, the judge would have to send him to prison for 6 years. Well, my client put his trust in me, whether that was the right call or not at the time, I don't know. But he said, let's go to trial. And we made some strategic decisions along the way that paid off. And ultimately, after a 2-day trial, we were right. He was acquitted of assault in the second degree, found guilty of everything else that we always said he was, and he ended up only getting 6 months in jail, right? Still a long sentence, still not a slap on the wrist. That's a long time to go away, but it's a lot better than 4 years in prison, a lot better than 6 years in prison. But sorry, I originally intended to spend more time kind of going through this, but this, I think, case presents a good example of me entering into negotiations, trying to work something out. A client who was guilty, right? He was certainly guilty of some crimes, but I still defended him because I didn't believe he was guilty of everything, and I didn't believe he deserved the sentence that the state wanted. So we went to trial, and then he got a very different outcome. He also put a lot of faith in me and asked my advice, right? Like, what should I do? And this wasn't a case where I could tell him what to do. It was, all I could do was say, look, here are your options. Here's what happens if you do this. Here's what happens if you do this. Here are the pros and cons of this. Here are the pros and cons of this. I can give you all the information in the world, but the decision is yours. And he made the call to go to trial. And fortunately for both of us, it paid off. Okay, I'm going to breeze through this real fast because most of it's not important, but some of the stuff was asked about. So how did I get here? I went to college at Oregon State University. I majored in political science. At the time I didn't even want to go to college. I wanted to enlist in the Army. I got talked into applying for an Army ROTC scholarship. I did that. I got it. So I went to college basically to please my family. But then in the end, I was so glad I did. I had no interest in going to college. And once I was there, I loved it. I loved every moment of it. I couldn't get enough, but I still didn't know what I wanted to do. Because I did ROTC, when I graduated, I became a commissioned officer in the military, but I went into the National Guard. I wanted to stay here with my now wife, my then girlfriend. I ended up deploying to Iraq. And while I was there, I was like, I got to figure out what I'm going to do when I get back. And I had considered law school before, but I wanted to take time to make sure that was really what I wanted to do, because law school is 3 years or 4 years, depending on whether you do a full-time or part-time program. It's 3 to 4 years you're not working, and it's very, very expensive. So I wanted to make darn sure that's what I wanted to do. I actually decided while I was in Iraq that yes, that's what I want to do. I want to become a prosecutor. So I went to law school at Lewis and Clark here in Portland. While I was in law school, I clerked at the Washington County District Attorney's Office and the Clackamas County District Attorney's Office. Those are both prosecutors' offices. And then my military status, I was actually a law clerk for a bunch of military lawyers down in Salem. When I graduated, I became an assistant attorney general at the Oregon Department of Justice. I was really bored. I was really, really bored. That's civil work. And in the 6 months I was there, I went to court one time. I was used to going to court like every day as a law clerk. When you're a third-year law student working at a DA's office, you essentially work as a prosecutor. And I really missed that. So I went back to Washington County, like I talked about earlier, and I did that for 4 years. And then I quit. And somebody asked me earlier why I made that change. I want to be mindful of what I say. I don't want to be trying to proselytize to any of you or besmirch my former profession or my peers on the prosecutorial side. But long story short, I was really unhappy doing what I was doing. I felt bad about what I was doing, right? The job of a prosecutor is to pursue justice. And I didn't feel like that was often what I was doing. I felt like the job was too focused on just convictions and sending people to jail. And I didn't really feel like I was doing a benefit. I felt like I was hurting people more than helping people. And so I was really unhappy. I actually didn't intend to become a defense attorney, though. I was pretty burned out on the law at that point. So I was intending to actually go back to school to become a teacher. Good thing for you all, I didn't do that. And Jason Short, one of the partners here, I had worked against him when I was a prosecutor and he was a defense attorney. And I saw him in court the day I put in my notice at the DA's office. And I told him, I just wanted to say, hey, it was a pleasure working with you. You're not going to see me anymore. And then he talked me into having lunch with him and then having lunch with him and the other partners here. And they persuaded me to give this a shot. And I love it. For the same reasons I didn't like being a prosecutor, I like what I'm doing now. It fits better with me, my philosophy, my belief system. I feel like every case I take, at a minimum, I'm helping somebody, even if it's just walking them through the process so that they know what's happening and they're not as scared. I've at least helped that person. I'm going to go to these questions real quick if I can get my mouse to work. Oh, so on that case I was talking about, why did the state charge him with assault? Did he fight with the police? No, he didn't fight with the police, not at all. It was for the driver of the other car. Even though it was accidental, unintentional, you can assault somebody recklessly. So by driving recklessly while under the influence and crashing into that other driver, he injured him and thus was charged with assault. Have you ever tried to claim your client was not guilty when they have told you they were? No. Well, certainly not with prosecutors or anything like that. I mean, that would be unethical, right? If I know my client did something, I'm not going to blatantly represent that they didn't. I cannot and I would not do that. Now, there's a difference though between did somebody do something wrong or are they guilty of the crime that they've been charged with, right? Has the state proven every element of the crime beyond a reasonable doubt? And so, yeah, maybe if I know my client did do something, I would still argue at trial that the state hasn't proven that he's guilty, right? It's semantics, but there's a difference. But certainly, I mean, if my client wants to go to trial, I can't just say, yeah, he's guilty, right? I have to do something to try to help them out. Do you get paid more if you win? No, we actually cannot do that. The rules of professional conduct governing lawyers state that defense attorneys cannot enter into agreements where they get paid more if they win, because that would present some weird ethical conflicts where maybe you're getting attorneys to do things or say things that they shouldn't be just to get more money. So we actually can't do that. We don't do that. And then the last question is, what happens if you lose a case? Yeah, it's my time. Well, my client gets sentenced. They get convicted and they get sentenced, and then we've got to argue over what's a reasonable and appropriate sentence. Do I participate in any additional trainings outside of law school? Yes, all lawyers have to go through what's called continuing legal education. We have to do 45 hours worth of ongoing education every, I think it's 3 years now. So we do that. I go to professional conferences. Yeah, I still do things to try to stay on top of the profession and the field. But also just every day you're in court, you're practicing, you're training, you're learning. I did have more, but I know I am past my time at this point, so I apologize. Thank you
All
for the
right.
comment. I really appreciate that.
Yeah, thank you so much. And hopefully we'll have you again next school year and we'll put more time to it because there's still more questions. That...
No, an hour's probably good. I'm a lawyer. I talk a lot. I just need to work on cutting it down.
Thank you so much.
Yeah, you're very welcome. Thank you for having me.